its concluding part, Srimad Bhagavatam predicts the miserable nature of Kali Yuga in various verses, one of them being, "He who can maintain a family will be regarded as an expert, and the principles of religion will be observed only for the sake of reputation." Srimad Bhagavatam 12.2.6. India, being a multicultural country, allows each citizen to be governed under personal laws relevant to religious views. This extends to personal laws inter alia in the matter of marriage and divorce. As part of the Hindu Code Bill, the Hindu Marriage Act was enacted by Parliament in 1955 to amend and codify marriage law between Hindus, as well as regulating the institution of marriage, including the validity of marriage and conditions for invalidity. The Hindu Marriage Act guides for Hindus to be in a systematic marriage bond. It gives meaning to marriage, cohabiting, rights for both the bride and groom, and safety for their family and children so that they do not suffer from their parental issues.
As we Indians celebrate our journey of 75 years of independence, Sansad TV pays tribute to the said remarkable journey by presenting a series titled 75 Years Laws That Shaped India, thereby discussing different laws that have been adopted during these golden years. I'm your host Hemant Batra, back with another episode in that exclusive series. Today we are deliberating the Hindu Marriage Act 1955. To discuss this progressive legislation, we have with us a very learned expert panel. We are joined by Rekha Sharma, Chairperson, National Commission for Women. If NCW is today known for working round the clock for addressing women's issues, it is because of her. Her pioneering efforts to be ever ready and reachable for women across the country. Welcome, Rekha ji.
Thank you so much.
Also joining is my good friend Priya Hingorani, Senior Advocate, Supreme Court of India, a well-known women's rights activist, and she has also been Vice President of the prestigious Supreme Court Bar Association. Welcome, Priya.
Thank you.
Rekha ji, according to Hinduism, Hindu marriage is regarded as, considered as, or let's say perceived as sacred institution, somewhat blissful and holy. But there are two schools of thought behind this concept of Hindu marriage, or let's say institution of Hindu marriage. One school of thought says that it is a social, personal bond. It's a private matter, meaning thereby that any law or state should not have any kind of intervention in this private relationship or matter. Then there is second school of thought, which says that no matter it may be a social bond, personal matter, but it enjoys an element of legal sanctity, thereby requiring some sort of law to regulate it. And hence comes the Hindu Marriage Act 1955. Do you consider this law as being a landmark, or let's say historic law in the journey of 75 years of India's independence, or let's say India's legislative journey of 75 years?
I do believe that it was a revolutionary act. In fact, it made a lot of changes in women's life after the act came in power. Because earlier men could marry as many women as they want, but after this polygamy stopped. It was
rampant.
Yes, it was very rampant in Hindu society also.
Right.
If you read any story, any story before that,
Yes.
They had many, even the kings had many wives,
Right.
you know.
Yes, absolutely.
And in general also, a man could marry anyone number of times.
Yeah.
So that stopped. Then the divorce, women could never go out and take divorce before this. But now
If they were in a bad relationship,
yes,
they could not.
never ask for divorce. Now they have equal rights for that also. And if they want to go separate way, they can ask for the divorce. Then the maintenance. Earlier there was no this thing law on maintenance.
Yes.
Now women in general, they can ask. In fact, both the partners have maintenance right. Even if a woman is earning and man is not earning, he can also ask for maintenance.
Right.
So that is also, so we can say that equality prevailed after this, equality in the marriage.
Very significant point you have made.
Yes.
The
So
equality
early-
is kind of the underlying feature of
yes,
this law.
when we are talking about a family, men and women should have equal rights. And this act made sure that both the partners should have equal rights. So I think that was a landmark act and a revolutionary one, changed society in a big way. And after that, so many changes happened in this act also. So as and when time, whatever required according to the time, things changed in this act.
Right.
So yes, I do welcome this, because I don't even imagine before 55 how women were living in those circumstances.
Absolutely. And I was listening to one commentary some time back where they said that, prior to 1955, marriage was more like a father gifting
yes,
his daughter.
Yes.
That kind of expressions was used, that gifting his daughter as a bride to the groom. So,
so now I think, in fact, few of the things I still see that जैसे वो करते हैं, दान करते हैं वो
दान,
जो
हाँ.
वो चीज जो है वो मुझे अभी
हाँ,
भी
वो
थोड़ा सा लगता
कन्यादान
है.
जैसे.
I didn't मेरी डॉटर की शादी में मैंने उसको दान नहीं किया, कन्यादान नहीं किया, उसकी जगह हमने एक कन्या आशीर्वाद कर दिया. सेम सेरेमनी बट नेम वाज डिफरेंट.
ये भी.
सो नेम वाज डिफरेंट. सो अभी भी मुझे लगता है लड़कियों को जो दान करने
का
वाली
वर्ड, मेरे हिसाब से डेरोगेटरी वर्ड है वो. वो भी बात ठीक.
या वी हैव टू done away with that ceremony.
Priya, let's start with the statute book, the act itself.
Yeah.
And let me ask you at the threshold very fundamental question, because we have to sort of get our facts right and clear. Tell me, what constitutes valid Hindu marriage? What are the conditions or prerequisites for a marriage to constitute a valid Hindu marriage?
The age is a factor of which constitutes a legal marriage, valid legal marriage. The boy has to be the age of 21 and the girl has to be above 18. Though that
which
is
now, though there is a bill.
There is a, that's why I'm going to
Bill.
say, though now there is a discussion and a debate going on of increasing the marriageable age of girls from 18 to 21.
Yeah.
So that's still under consideration. But as per the existing law, it is
Yes.
21 and 18.
And 18, okay.
They should not be related to each other within the same family, brother,
Right.
sister, or even cousins. It's ideally recommended that they should not, it's not a valid marriage.
Okay. So there are some prohibited relationships.
Relationships which
I
you
see.
have to keep in mind.
Okay.
The third thing is that they have to, ground of insanity. They should not be a person who of mental unsound mind.
I see.
And all those issues are also
there.
looked into.
Okay.
So basically, for a marriage to be valid, there should not be an existing wife or an existing husband. If they are in a relationship, that divorce should have taken place if you want to get remarried again.
Right.
But you cannot get married again to another person if the person is already married.
Right. So
that does
polygamy
not
is a history now,
so it's
as
not-
Rekha was
but
saying. Yeah.
it's still happening in some
Yeah.
in some parts of the country, but that's something. Then it's not a valid marriage.
Right.
So there are disputes related to that, and so.
But bigamy is mentioned in the act, but the prosecution happens under the Indian Penal Code. isn't it?
Under the Indian Penal Code.
Right.
But the thing is, a lot of people, particularly in the tier 2 cities, we find, when we do all these cases, is that they do, if the wife has left or if they have separated, they will go and have a live-in relationship or get married to that person, but that doesn't come out. till a matter is in court or
So
is
practically
taken up.
speaking,
Some cases are still happening.
it's very difficult to prove that those
Yes,
persons are
because
married.
now
if they're
live-in
living
relationship is accepted. There is a legally live-in relationships are accepted. You have maintenance for a live-in relationship. So there are other.
So which means the law has actually evolved. It's not very tight-jacketed as it is in letter and spirit.
Yeah, but if you talk of a valid legal marriage, these are the prerequisites.
Right.
But yes, apart from a valid legal marriage, the concept of a live-in relationship is also coming into our country and is found legal.
Right.
Yeah.
Rekha ji, another question which comes to my mind is about the ceremonies. The Hindu marriage is centered on religious ceremonies, rituals, activities, and so on and so forth. And in fact, even the act propagates that for solemnization of Hindu marriage, there should be there should be ceremonies like Saat Fera, 7 steps,
Shatpati.
Shatpati, yes. Yeah. And but with the changing times, I'm noticing that Hindu marriage has become more of a celebratory event. It's a social media event as well, and even the courts have started giving more weightage, precedence, and should I say acknowledgement to the registration of marriage rather than the ceremonies. So, what is your take on this?
See, ceremonies do make, according to Hindu Marriage Act, a very important part of the marriage. It always also gives social sanctions when people gathers in the marriage. So you are announcing that you are together and you have proof of marriages. Now, when the court asks, they do ask about the picture of the marriage. Kahan fere hue, nahi hue,
Pandit kaun tha.
And when things go to the court, then they ask and
they do ask.
And even when you go for the registration of marriage, they do ask where you got married, where Pandit tha kaun or kaun si jagah pe tha. So I remember when we, after so many years of marriage, went for the registration of marriage, they asked all these questions. This is very important, and according to Hindu Marriage Act, I think they do need certain ceremonies to be performed, whether Shatpati or traditionally jo bhi kisi bhi according to Buddhists, they may have some other rituals. So they do ask about rituals also and society. But as you said, according to the changing time, it is more of showing off the money and money power, and it is more of
how many singers have you called
especially in
for
North,
performance?
Especially in North India, when you see the South Indian marriages, they are more on traditional way, their puja part and a short ceremony.
Right.
So I think we should choose in between whether you are going for ceremony or not, but you should have little small ceremony where you can call your loved ones, your small family, and do the rituals as per Hindu marriage. Shatpati jo bhi karna hai, ya sardaron mein chote se fere, 3 फेरे ही होते हैं, 4 फेरे होते हैं, not 7 feras, whatever the rituals are.
Rituals should be, yes.
But yes, the showing off of money power should not be there, because then the stress is on girl's family.
Right.
How much money they are spending, and when a society
it goes against the spirit of the law.
It goes against the spirit of marriage also. I think uski sanctity bhi khatam ho jati hai when you are spending only money and dances and liquor, flowing of liquor. This should not be.
मुझे तो लगता है कि जैसे इलेक्शंस में उन्होंने एक्सपेंडिचर रखा है इलेक्शन कमीशन ने, मैरिजेस के लिए भी अब जरूरत है कि एक्सपेंडिचर.
अभी हमने लॉकडाउन के दौरान we have seen that marriages were happening with small amount of money also, and they were enjoying as much as
yes.
So you should, I think we should have that kind of thing that 5 लाख से ऊपर नहीं खर्चना इस शादी में, या 10 लाख. So आजकल there is no limit on spending money.
Quickly, Priya, in some few words, if you can tell us, there is this question which is bothering me about restitution of conjugal rights. I can't reconcile to that provision of law. The parties to the marriage are not some kind of commodities that you can pick up from one place and transplant them in another house against their wishes and desires. Is that provision of law actually workable and practical?
See, I think this is a pre-independence kind of a section which was included because it was very prevalent in UK, and we followed that system. The
restitution of conjugal rights, yeah.
So Section 9 of the Hindu Marriage Act talks of restitution of conjugal rights. Now, what does that mean? It means that if one party has left the house and walked out of the marriage, then you can move the court and say, please ask them to come back and resume the conjugal rights, or live as husband and wife, look after the family, be part of the same family. But yes, practically you cannot force any two individuals, whether it's brother, sister, or even a husband, wife, to live together if they don't want to or they don't desire to. So in effect, as of now, this is actually under challenge in the Supreme Court now, so it is sub judice.
I see.
There is a PIL file in the Supreme Court challenging the validity and now whether it should continue on the statute book or not. But yes, in effect, it has actually become a redundant kind of a section or a matter in court, because even if you get a decree of a restitution of conjugal rights, you can't execute it. You cannot execute it. It is very difficult. You can't force anybody to come. So there are people, or there are lawyers, or there are people who do advise, or people who do want to file that because they don't want to go into litigation of divorce, or they don't want to go in for a domestic violence case, but they want to give their marriage a go, an attempt to see if it can still work. So they do file petitions of restitution conjugal rights. Now, the other reason for filing this is because in this you are entitled to maintenance. So there are many cases where they file this case so that at least if the court directs them that even if you are not staying or till the matter is decided, a certain amount of maintenance is awarded to particularly to women, because you find most women filing these kind of the cases under Section 9 rather than males. They, in fact, if a woman walks out of the house, they say, I'm deserted, and they go in for divorce. So, the thought process is very different. So, it is still on the statutes, it is still being used, but very sparingly. But I think it is now, in a way, with the evolving society and the thought process, is becoming more of a redundant section.
Well, within a traditional framework reference, marriage is undoubtedly the most important transitional point in a Hindu's life, and the most important of all, the Hindu sanskaras. In other words, life cycle rituals. We will discuss more about the law, but after a very short break. Welcome back after the break. You're watching our special show on selective landmark laws legislated during our journey of 75 years of independence. Today we are discussing a substantial law, the Hindu Marriage Act. Before continuing our discussion with the experts, let us also gather about the initial journey of this law in the Parliament.
The Hindu Marriage Bill 1952 was introduced on 12th of November 1952 in the Rajya Sabha. The said bill was debated and passed in the Rajya Sabha and the Lok Sabha on 5th of May 1955 and 15th of December 1954 respectively. The said bill received the assent of the President of India on 18th of May 1955 and was brought into force on the same day. Let us see some of the relevant passages from the parliamentary debates at the time the bill was taken up for discussion.
We talk about 5-year plans of economic progress, industrialization, political freedom and all that. They are all highly important, but I have no doubt in my mind that the real progress of the country means progress not only on the political plane, not only on the economic plane, but also on social plane. They have to be integrated, all these, when the great nation goes forward.
This bill was not a revolutionary measure. So, in the year of grace 1955, you find the Victorian concept of divorce incorporated in the bill. You also find that archaic provision for the enforcement of conjugal rights by the courts of law. This is a bill which is a compromise between reaction and reform, between the old and the new.
We have to look upon this bill which is coming as a piecemeal law, dealing with various outstanding measures of social reform, especially dealing with the institutions of marriage and family life. Therefore, it is wrong to take up this attitude that if we pass this bill, then all women will become equal in society. That is absolutely wrong.
I think the government today is not prepared to bring one uniform civil code. But I hope the day will soon come in the future when we shall be able to have one uniform civil code.
Rekha ji, returning back to our discussion, do you think that the time is ripe now for uniform civil code? More so because even Article 44 of the Constitution mandates it.
I think this is the right time for UCC, because when you're talking about the rights of women, how can our religion can take over on the rights of women, whether she is from Muslim community or from Christian community or from Hindu?
Yes.
Their rights should be similar.
Right.
Whether it is marriage, divorce, whatever you name it, succession, adoption.
Yeah.
In all these things, the law should be the same.
Yeah. Religion should not define.
Religion should not be. And when we are talking about one country, how the laws can be different in one country. Right. We are not governed. We should not be governed by religion. We should be governed by the law of the land. And when we are talking about marriage, why Muslim women should suffer by polygamy? They still have to suffer with that, whereas we don't. So I think this is the time. This is the right time that we should talk about. And minorities also should not take it as if we are, controlling, the law is controlling them. It is about the rights. It is not
it's
at
about
all
the rights. Yeah.
It is
Absolutely.
right about, and I'm more concerned about women as NCW chairperson.
Absolutely.
And they should have equal rights.
Absolutely.
Whether it is adoption or succession also, because they don't have equal right in succession in many of the communities, and so we should talk about that.
Yeah, and as you just mentioned that you're the chairperson of NCW, so in that capacity, or let's say in your experience, do you think that the current law, which has been there in existence for last 7 decades, needs some sort of revamp?
Yes, because especially in divorce, when we are talking about divorce, why should have reasons of fault? That should that should not be there. Right. If you want divorce, it should be very simple. Why
very
should
progressive.
Why should we go in court and mudsling on each other? And when a woman comes, the first thing man will always target the character of a woman in the court. So if the relationship is irrepressible, you can't have a proper relation, you should go and take divorce rather than mudslinging on each other. So this fault thing should go away in this. That is one thing which I wanted to talk about.
Very, very valid point. Priya, talking about divorce, what all grounds exist today in the Hindu Marriage Act?
Yeah, so the grounds basically are cruelty, desertion,
I see.
Unsound mind. You also have, if a person is not disappeared for 7 years and you cannot see the person, if he gets married, has another marriage. So there are some certain grounds which are available for either party to move the court for taking a divorce. But what happens is, in India now, the one point which I would want to mention is very progressive, or I think the courts have felt, and even the parties feel, that it is best to go in for a divorce by mutual consent, and that provision is, one of the finest provisions that we have in our Hindu Marriage Act, and it is also there in, of course, in Special Marriage Act and the other acts, but not so much with the Parsis and the Muslims, Muslim Act, Marriage Act. But the fact that you can go in for a divorce by mutual consent. And the other aspect which I think is very progressive, for which I do want to highlight, is the fact that mediation, pre-litigation mediation, and mediation is another important branch of jurisprudence which is coming up.
That's very important.
Particularly in matrimonial matters, where you can go in before a observer, an independent person, resolve, reconcile your disputes, resolve your disputes.
And it is kind of in camera.
In camera confidentiality.
Confidentiality is there.
You have an external personnel, a trained person listening to your issues and trying to resolve you and taking you towards a resolution.
Yeah.
The person is just a facilitator, but he's taking you towards a resolution. Right. And just one more point I want to make.
Sure.
In India, and this is what I mean, I come from a family of lawyers, and my mother, Kapila Hingorani, was part of the women's movement when it started in the early 80s. She has been propagating, and I think women like Rekha ji and we all have been saying, and I think men have also supported us, that in India, we don't have an Indian woman. We have a Hindu woman, we have a Parsi woman, we have a Christian woman. So it is the need of the hour to have to be known as an Indian woman. The Constitution
so uniformity
mandates that.
becomes very important.
The Constitution mandates that.
Mandates it. Article 44.
But unfortunately, we don't have it. So time has come for us to be able to say, I'm an Indian woman.
Yeah, very well said. Well, as is our customary practice, the last question of the episode is reserved for our prized viewer. This time, we have a question from law student Dhruvi Sikarwar. Let's listen in.
It is seen that during the divorce proceedings and even upon the divorce, the wife always gets the alimony and maintenance. Can husband not seek or get the maintenance?
That's a good question. What do you have? See, we have been talking about women. Let's talk about men also.
Yes. Yes, you're absolutely right. By and large, it is women who do get the maintenance and are needy of the maintenance and the alimony. There are few cases where, yes, if the woman is working, as Rekha ji said, if she is working and she is doing well and better than the husband can ask for maintenance and claim maintenance. Okay. He is not debarred under the Hindu Marriage Act for asking or claiming for maintenance.
But there have been instances that where the men have got, husbands have got the maintenance.
I in fact did a matter which is there a Bombay High Court had directed that the husband to be paid maintenance of 50,000 rupees per month from the wife because she was working and she was doing much better than him. Of course, she challenged it. The order was set aside, and when we came to the Supreme Court said no. Well, he needs the money. He doesn't have the money, so it was upheld. So yes, there are but very few instances where it has happened. But yes, you can claim. There's no bar to it.
Right.
But alimony is something which is usually given to the wife to look after herself post divorce, because most often women do not get married again. So that's kind of a security,
so that's
a financial security. Yes, for her.
She's not working most of the time.
And most of the time it's a financial security for her.
Right. Well, it is time to bid goodbye for now with a thought-provoking remark by none other than Swami Vivekananda, who said that according to Hindu way of living, marriage is a duty than a privilege. Remember always. Thank you so much, Rekha Sharma and Priya Hingorani, for joining us and sharing your expert views. That's all we have in this edition of the program. You can send your feedback at Sansad TV at sansad.nic.in. You can also connect with us on various other social media platforms. Thank you for watching. Goodbye, good luck and namaskar.